In arguments that lasted more than 3.5 hours, the justices of the Utah Supreme Court asked some very pointed questions about Amendment D as they decide whether it should go on the ballot or not.
What happened?
Would you agree with that?
The justices of the Utah Supreme Court had a lot of questions about Amendment D.
I wonder if that changes.
The legislature is appealing a lower court's decision to void Amendment D. Passed in a special session, the proposed constitutional amendment would override the Utah Supreme Court's original ruling that lawmakers overstepped their powers when they overrode a citizen ballot initiative on independent redistricting. The League of Women Voters and Mormon Women for Ethical Government argued that what lawmakers put before voters on the ballot is misleading.
Whether Amendment D ultimately succeeds or fails should be left in the hands of Utah voters.
The justices focused on some key issues, including whether the legislature met constitutional requirements to publish notice in a newspaper or if an online link is okay.
I'm not sure that we can just overlook this language where we still have newspapers, and the legislature, in fact, is still today putting into statutes notice requirements that go into newspapers.
We agree newspapers still exist. The question I think the court has to answer, is it okay if it's going in the e-bulletin of the e-edition of the Salt Lake Tribune instead of the weekly or bi-weekly edition?
There's no question that the legislature did not cause it to be published in the newspapers 2 months before the election, unless we buy your other argument that just making passing a newsworthy amendment is enough.
Either you complied or you didn't.
They also grilled the legislature's lawyer over the ballot language itself and if Amendment D is misleading to voters.
Citizen ballot initiatives that reform the government will now be subject to a legislative veto. Where does the ballot summary tell people that?
I don't agree that the effect of the ballot will subject citizens' initiatives to a veto.
Lawyers for the plaintiffs argue voters will be left confused.
If we were to require that the legislature basically flood the airwaves and the newspapers, both online and hard copy, why wouldn't that serve the constitutional objective?
The sort of fundamental problem is it does nothing to remedy the misleading and inaccurate ballot language.
The plaintiffs hope the court sides with them.
I have trust in the Utah Supreme Court to make a good decision here.
I think it had to be very difficult for the legislative attorney to try to represent her client while not lying to the public.
In a statement, House Speaker Mike Schultz says he appreciates the discussion and looks forward to the court's decision. Meanwhile, the campaign against Amendment D continues just in case.
Because this is too important to leave to time and last minute. So certainly we will continue to advocate that Utahns vote against Amendment D if it is in fact on their ballots.
So the justices took the case under advisement. There's no timeline for when they'll issue a ruling, but ballots will be mailed out starting in mid-October. At the Matheson Courthouse, Ben Winslow, Fox 13 News, Utah.